My name is Samir Shin and I'm the branch chair of the West Midlands CR. I've previously worked as an engineer in the oil and gas sector, but now work as a consultant for Advantage RSK that provides commercial and project management services in the engineering and construction services. The West Midlands branch promotes and hosts topics on alternative dispute resolution, even if they're not specific to the West Midlands region in the UK. If anyone has any ideas for future events, please don't hesitate to contact me. I'll leave my email in the chat function in case that there's a specific topic that you'd like us to organise. For today's webinar, I'm honoured to have two speakers who have in-depth knowledge of oil and gas agreements in Africa. Our first speaker is Professor John Patterson of the University of Aberdeen. Professor Patterson trained as a solicitor in the Office of Solicitor to the Secretary of State of Scotland before pursuing an academic career. Professor Patterson is a co-founder of the Centre for Energy Law and directs the University of Aberdeen's involvement in the North Sea Energy Law Programme. His research has covered regulation of risk, corporate governance and energy law, and has been involved in international projects both in research and in teaching. He has provided specialist training in oil and gas law for the corporate sector and expert advice in international arbitrations. Our second speaker is Dr. Eddie Whiffer. Dr. Whiffer was a senior partner at Ascendo Juris, a Nigerian-based law firm, and is now an energy law lecturer at the University of Aberdeen. As a lecturer in energy law, he has contributed to courses including petroleum resource governance, oil and gas contracting, decommissioning of offshore installations, low carbon energy transitions, and alternative methods to dispute resolution. His fields of research include petroleum and natural resource governance and regulatory theories in high major risk industries. Dr. Whiffer is a member of the Nigerian Bar Association and the Society of Legal Scholars. So before, if you do have any questions during the talk, please actually use the Q&A function and we'll answer these at the end of the talk. So may I hand over to Professor Patterson to begin? Thank you.
Thank you very much, and thank you to you, Samir, Anita, for the kind invitation to speak to everyone this evening. So, as Samir said, our topic this evening is the issue of dispute prevention and dispute resolution in the context of production sharing agreements. And I'm doing that on the basis of a study of contracts in sub-Saharan Africa. And I'm not going to use PowerPoint this evening, so I'm just going to speak. But if anyone is particularly interested in this, the paper on which this is based is freely available, and we can share the link with you. So if anyone wants to follow up, that would be absolutely fine. So let me begin by giving a little bit of context. What are the contracts that we are concerned with here? So a production sharing agreement, as the name suggests, is an agreement which allows the parties to it to share oil and gas production emerging from the particular project that the agreement relates to. And of course, the parties to that kind of agreement are, on the one hand, the state, the host state, and usually international oil companies. So we have very interesting parties in the context of these agreements, because we've got state parties and we've got some of the most powerful companies on the planet. So you can see that the potential for things to get a little bit interesting is quite high. And of course, not least because we're dealing with something as economically and politically sensitive as hydrocarbons. So what I'm going to do is give you, first of all, a little bit of a sense of why these agreements are made use of in the first place, what the alternatives would be, and then why these are contentious. And then we'll go on and take a look at the ways in which, over time, there have been efforts to make them somewhat less contentious, and in particular, to set them up in such a way that we try to avoid disputes in the first place, we try to prevent them occurring, and then to think of ways in which, if disputes do arise, we can resolve them in a way which is as mutually beneficial to the parties as possible. Now, of course, that's a counsel of perfection. Let's see how things turn out in practice. And of course, Eddie is going to comment on these ideas after. So first of all, clearly we're dealing with a situation where a state suspects that it may have, or it knows that it has hydrocarbons present in a sedimentary basin. And then the first thing that it has to do in those circumstances is to think about what kind of arrangement are we going to put in place that will allow commercial actors to come in and help us explore for and hopefully produce oil and gas. So in essence, we're in a situation where the state has determined that it's not going to be able or doesn't want to devote its own capital to this kind of project, but rather it's going to rely on the commercial sector to some extent. And then it's got a variety of options that it can choose from in terms of how it goes forward. The one we're interested in this evening is the production sharing agreement. I'll talk more about that in a minute. But to give you a sense of the other key alternative, it's the one that we use in the UK, and in fact, one that's used, generally speaking, in most what we might call developed jurisdictions. And that is the license and tax model. So in the license and tax model, as the name suggests, the companies who are going to explore for and hopefully find and then produce hydrocarbons are granted a license. It gives them the authorization to go and explore for and hopefully produce hydrocarbons, which of course belong to the host state. And in terms of how the state itself will get a share of the value produced, that is achieved principally through taxing the profits of the licensee. Okay, so that's the model that we use here in the UK. It's something that is often rather arcane. Unless you're involved in the industry, you tend not to think about it. But lo and behold, just in the last week, of course, it's been in the news because the government has decided to impose a windfall tax. In other words, there is a sense that at present, with the oil price being so high, the upstream companies who are producing and then selling the UK's oil are making an excess profit or a windfall profit above and beyond what would have been required to incentivize them to take the risk in the first place. And therefore, the government says we're going to impose a windfall tax to take away that excess profit, still leaving the industry with what they would regard as a reasonable rate of return, but taking that excess from them. And that, of course, also gives us a sense of how these production sharing agreements can become contentious, because what we're dealing with, of course, is a situation where if we're not going to use the license and tax system, we're going to enter into production sharing agreement, state and the commercial sector, international oil companies, they're entering into a contract. And that contract, of course, if hydrocarbons are discovered and produced, could well endure for 20 years, 30 years, 40 years, even longer. So we're dealing with a very long-term contract. That's the first thing. And then, of course, as the example we just talked about of price shows us, we're also dealing with a contract which is beset with uncertainty. Now, price is one. We know that the oil price is very volatile. It's not so long ago, in the context of the COVID lockdown, that we had at least one benchmark turning negative. The price was negative. And of course, at the moment, we're talking about a price that is north of $120. So we've got extreme volatility. So you can see already there is a challenge for the parties in coming to some sort of agreement that somehow accommodates that huge diversity of price for the commodity, which, all else equal, your costs are relatively fixed once you're up and running, and yet the income that you can derive could be hugely different from 1 month, 1 year to the next. And that's only one of the uncertainties. We've got others, of course, as well. These are risk contracts. In other words, if the commercial party does not make a discovery, they will not be compensated for the work that they have done. So that's the geological risk. They're going into this, they are carrying out geological exploratory techniques, and then they're going to, if they have prospectivity, they're going to drill. They may find nothing of commercial value, but they will not be compensated for that work. That's the geological risk. And then, of course, we've got things like currency risk, fiscal risk, political risk, so it goes on. There are so many things that can change over the course of such a long-term contract. Now, what that means, of course, is that the parties have an interest in some kind of stability or equilibrium within the contract. On the other hand, of course, they also have an interest in being able to adapt the contract or move the contract around depending on the situation. So we have then this kind of tension within the contract between a kind of desire for stability. We want to know what our obligations are and our rights are. On the other hand, we know we're dealing with potentially a lot of moving parts, so we want to be able to be flexible when that's appropriate. But of course, we know that when one party would like things to be flexible to their benefit, that may well be to the detriment of the other. And of course, when we think about contracts in a rather kind of simplified way, we tend to think of them as kind of discrete one-off transactions where it's a bit of a zero-sum game. If I win, you lose, that kind of thing. But in the case of the sort of contracts we're talking about, we might regard these as kind of the paradigm case of the relational contract. Both parties need each other, and they need each other for the long run. In the case of the state, it has the ability to grant access or deny access to the resources. In the case of the commercial party, it has the capital, the expertise, the technology to be able to explore for and get the resources. You can't have one without the other. They both need each other, and they need each other in the long term. This is not a kind of one-shot transaction. This is an ongoing relationship. So here's the challenge then in drafting this kind of contract. How do we make it sufficiently stable to reassure an investor that they can commit what could be very, very significant resources in the long term? How do we reassure the state that in the event that there are the kind of changes we talked about a few minutes ago, for example, sudden huge increase in the price, that they can move the distribution of value in such a way that they are not allowing the commercial sector to run off with the family silver, run off with an excess or a windfall profit. So that's the challenge for the lawyers in negotiating and drafting these contracts. So we can see how there's a kind of tension built into these. Equally, you can see how there is an interest for both parties in achieving something that has these qualities in the long run. Now, let me move on a little bit, because we know from the example I gave of how we deal with changes in a license and tax system. You're granted a license, there's no stabilization, there's no stability built into the license in terms of what's the tax regime going to be. You go in, you receive a petroleum license knowing that. It's then a matter for the state itself and its parliament, its legislature, what the tax arrangement will be from month to month, from year to year. And in the case of the UK, the tax regime for oil and gas has changed pretty much every year, sometimes more than once a year for the past half century. So it's a very mobile situation. When it comes to the production sharing agreement, there can be a tax element, but the key way in which the value will be distributed between the parties is, as the name suggests, by sharing the physical oil or gas, or oil and gas, that is produced under that contract. So what will happen is, in a given accounting period, there will be a certain amount of oil, let's say, to be distributed. And what will happen, first of all, is that an element of that amount of oil will be attributed to the contractor, to the commercial party, as so-called cost oil. And that is oil that is given to them, or attributed to them, to compensate them for the costs that they have incurred, both their exploration and development costs, as well as their ongoing operating costs. Now, of course, we need to have some kind of ceiling on the cost oil, because you can imagine if your upfront costs were several $billion, if you were taking all of the, you were trying to recover those costs as quickly as possible, you could be taking all the oil for several years, perhaps, before anything was available to the state. So usually what we'll find is there's a ceiling on the cost oil, might be something like 60%. So you can get 60% of the production to cover your costs, and then anything that's left will be profit oil. Now, there are other complications as well, but I'm simplifying this given time constraints. But in essence then, where the action really comes is in how we're going to distribute that profit oil, because that's the key way in which value is going to come to the state, as well as value going to the contractor. And the question then is, and of course this is a matter for negotiation between the parties, what percentage are we going to give to the state, and what percentage are we going to give to the contractor? So we could do it very, very straightforwardly. We could say 50-50. And that actually happens. There are some few examples of a straightforward 50-50 split. So anything that we are allocating after cost oil has been attributed, will simply divide half and half between the two parties. But that's unusual. It does happen, but it's unusual. And it's unusual because that is not really in the interests of the state party to divide it in that way. It's actually much more usual for there to be a sliding scale. In other words, the precise percentage that goes to the state and to the contractor will change depending on certain circumstances. So if we look in older contracts, we might find a sliding scale that is based on changes in price, okay? We might find one that has a sliding scale based on changes in levels of production. So those were the kind of classical ways of dealing with this once sliding scales became a common feature. And of course, the idea is that if the price goes higher, we're actually going to give a smaller percentage of the profit oil to the contractor and a larger share to the state. You can see that's a way of the state taking the kind of windfall, the excess element. They're going to get a bigger share if the price goes higher. Similarly, the assumption is that if costs are relatively level, if production levels go up, then again, the higher the production level, the bigger the share of the profit oil will give to the state and the smaller the percentage that will go to the contractor. Now, sometimes when people look at that for the first time, it seems counterintuitive because where's the incentive, if you like, for the contractor if they're producing more, they're at a higher level of production, but they're getting a smaller share. But of course, the idea is to negotiate this and draft it in such a way that the contractor always remains incentivized. Even if they're getting a smaller percentage, they're still getting more value overall when they move up through the production levels. But you can see also that what is going on here in terms of a sliding scale based on price levels or on production levels is an effort to track the profitability of the contractor. Because the more profitable the contractor is because they're producing more oil or they're getting a higher price for the oil they produce, the more risk that there is that they're taking an excess profit, they're getting a windfall, in which case we want the state to be able to take that excess, keep the contractor happy, by all means keep them incentivized, make sure they're getting a reasonable rate of return on their investment, a return that reflects the risk that they have taken, but we don't want to give them more than that. That would be inefficient and also unfair to the state. But of course, both price and production level are proxies for profitability rather than being necessarily an accurate measure of profitability. So as time went on, we saw a more sophisticated effort to calculate profitability, a so-called R-factor calculation. Lots and lots of different ways of doing this. Some of them really quite complicated and well beyond the mathematical abilities of a simple lawyer like me. But the essence in each case is that we're trying to have a kind of calculation of cost versus income, and we're trying to track profitability, and we're going to move the share going to the contractor and the share going to the state on the basis of the level of profitability. The more profitable the contractor becomes, the smaller the share of production that we'll give them, and the larger the share we'll give to the state, and vice versa. And in modern production sharing contracts, that's very much the normal approach that you would now find, an R-factor sliding scale. Now, what's all this got to do with disputes? Well, of course, the idea is that in as much as we have that sort of self-adjustment built in, we're actually, in a quite sophisticated way, trying to prevent disputes from occurring, because the contract itself is maintaining some kind of equilibrium on the basis of what was agreed right at the outset. We know that profitability will change for a whole range of reasons, and that way of doing things means that we avoid a dispute because the parties can see they're going in with their eyes open, there's transparency about how we're going to calculate these things, and the equilibrium is maintained as the contract goes forward. So that's all great. Now, with the best will in the world, we can't account for all future states of the world, however hard we try. There could be a change in the price out of all the sort of foreseeable circumstances when the contract was signed. So we're going to sort of breach the kind of agreed sliding scale levels. Equally, other things could come to pass that take the contract out of that equilibrium. And in those circumstances, we find that the contractor, of course, has an interest in stability. Tell me the rules of the game at the start, and then don't change the rules once we started playing. That's what they want. But of course, if the circumstances change to such an extent that the state says, well, look, I can't live with this anymore. I need to make changes. I need to make a change to fiscal arrangements, or I need to make a change to regulatory arrangements, or whatever it might be. If we have too much rigidity, too much stability, the state is disadvantaged. But actually, that is what historically companies really stipulated for and made an effort to negotiate for. And historically, it's something that states were actually willing to grant. And these, of course, are the famous freezing clauses. So a form of stabilization clause in a production sharing agreement, which has the character of a freezing clause. Now, again, there are all kinds of varieties, but again, for the sake of simplicity, given the time that we have, we could put it like this. The freezing clause essentially is freezing the law that will relate to the contract as at, let's say, the date of signature of the contract or the effective date of the contract. And of course, what that is doing is it's granting the contractor that certainty, that stability that they crave. Tell me the rules of the game and then don't change them over 25, 30, 40 years. So the law applicable to the contract will be the law as at the date that it was signed or becomes effective, something like that. Now, of course, that all looks fine right at the beginning. The contractor gets what they want, they're willing to invest. But at a certain point, the state wakes up one morning and thinks, well, hang on a minute, what have I done? I have essentially constrained my ability to govern. I have put a constraint on my sovereignty because everyone else in the land is going to be subject to changes in the law. But this particular contractor, international oil companies, have managed to carve out this little enclave where changes in the law will not affect them. Now, you can understand then that these clauses have been extremely controversial. And they have been subject of a lot of criticism from academics, but also a lot of political criticism as well. And it's not unusual for these issues to come to light sometimes when a dispute arises and the tension is there and the state is saying, well, I can't live with this anymore. I do need to make a change. And all of a sudden we have a big dispute. And the contractor is saying to the arbitral panel, well, sorry, I see what they're saying, but the thing is they agreed to the stabilization and therefore, I'm quite entitled to require them to stick to that. Now, what has happened in practice when these clauses have become a matter of controversy, and again, I'm kind of generalizing, but this gives you a sense of what has happened. Generally speaking, arbitral panels have said, well, the thing is, you really can't, as a contractor, expect the state to be unable in all time coming or for the duration of this contract to change the law in a way that will affect you, contractor, because there may be entirely legitimate reasons why they want to do that. On the other hand, the panels have said to the state, yeah, okay, so we know that you must be able to change the law. You are the sovereign. You must be able to change the law within your jurisdiction. But the thing is, you or your predecessor did actually agree not to do that. So, of course, we can't stop you from changing the law and we can't stop you from applying it to the contractor. But what we can do is then require you to pay compensation to them. Okay, so the freezing clause has never really worked in the way that they were intended to, but they have produced results which have kind of split the difference a bit between the parties, but not necessarily in a way that has made anybody happy. So as a consequence, it's actually now really unusual to come across that kind of freezing clause in more modern production sharing agreements. No one would really think it was a good idea to do it. Instead, what we find are a wide variety, there's no kind of set form for these, but a wide variety of clauses that are essentially what we might call economic equilibrium or economic balancing clauses. And what they then try to do is not to freeze the law or do anything like that. What they're doing is recognizing that over the course of such a long duration contract, and one that involves, you know, multiple uncertainties, a word I could have used earlier is that these are kind of, again, classic examples of incomplete contracts because of the number of uncertainties as we go forward. Because of these circumstances, we recognize that circumstances may arise where one or other party may get to a point where they say, okay, the contract is now out of the balance that we anticipated when we went in, beyond any kind of ability of the contract to self-adjust, for example, via the sliding scales. And therefore, what we need to do is to renegotiate the contract in order to bring it back into equilibrium. So we often see again, everything depends on the individual contract. So we might call them balancing clauses, equilibrium clauses. Very often they are explicitly involving renegotiation. So one or other party is able to trigger a renegotiation when it encounters this kind of material impact on the equilibrium of the contract. And again, the wording varies from contract to contract, but that is the essence of what we're dealing with. Now, in those circumstances, you can see that we can agree to be able to trigger a renegotiation, but we can't agree that we will agree in the event that such a renegotiation is triggered, because that would be unreasonable. So what will happen is that one or other party can trigger the renegotiation. The contract will usually then require that the parties will renegotiate in good faith and will try to reach a mutually acceptable agreement, often phrased in terms of, you know, the equilibrium of the contract. And there will usually, well, there will always really be a time limit on that. If they can't agree within a reasonable time or a set number of days or months, whatever it might be, then there will be some kind of pressure valve, safety valve, where, okay, we've done our best, we've renegotiated in good faith, we haven't been able to reach an agreement, therefore we're going to have resort to the dispute resolution arrangements that are included in the contract. Because another key feature of production sharing agreements is that, again, really almost without exception, they presuppose that there will be international arbitration. Or there could be other arrangements short of that, for example, reference to a sole expert or something like that. But they will pretty much always have, as a long stop, if you like, the opportunity for international arbitration. So in the context of that renegotiation, in the event that the parties have renegotiated in good faith, aren't able to reach a decision, it would then be handed over to, let's say, an arbitral tribunal. But then, of course, things get interesting again, because what exactly is it that we're going to ask the arbitral panel to do? Are they going to ask for the two parties to come forward with their best proposals and say, well, we picked that one or not that one? Are we going to give the panel the power to adapt the contract? So these are issues that are very much being discussed as we speak. These are kind of live issues in the whole area of international arbitration, not just in the context of PSAs, but in international agreements more generally. To what extent are we able to rely on an arbitral panel to adapt the contract? Now, a couple of things to say here, and I'm mindful of time, I don't want to go on too long, but a couple of things before I hand over to Eddie. The first one is that in the context of PSAs generally, the presence of international arbitration has itself been controversial, because from the point of view of the international oil companies, they've gone into these contracts and they have said, in essence, well, okay, we're coming to invest in a host state. We are potentially going to be investing billions of dollars. We're worried about what happens in the event that there is a dispute. Can we be certain that a local court, domestic court, would give us a fair hearing, or are there circumstances in which the court will perhaps almost by default find in favour of the state? And of course, that's a legitimate concern in some cases, perhaps less so in others, but that tends to be the way things have been seen from the perspective of the companies. Now, on the other hand, from the point of view of the state, this is a big deal, because we're talking about the state's natural resources. In many cases, we could be talking about resources which will constitute perhaps the most significant economic sector in the state. And yet, in the event that there is a dispute, that will not be a matter for the domestic courts. Rather, we're going to hand that over to a tribunal composed of foreigners in another country altogether. Even if the applicable law is the law of the land, we know that there's also going to be a real effort on the part of contractors to internationalize the contract. And then the concern is that where the dispute is settled, is it really being settled in a way that properly considers the interests of the state, or is this being settled in a way that is, very much favourable to and accommodating of international commercial actors rather than state parties? So these are the issues that are of concern generally. Now, beyond that general point, we've got the more specific one of to what extent are we willing, in the case of these renegotiation clauses where we can't agree, to what extent are we willing to allow such a panel to essentially rewrite the contract, to adapt the contract? And if we do that, are there any principles or guidelines that we could have recourse to or refer the panel to that might give us some sort of reassurance about the limits within which they will operate? So in the paper that this little presentation is based on, which I did a couple of years ago, in essence, one of the things I pointed to was the OECD's guidelines for durable extractive agreements. At that time, when the paper was written, these were in draft, but they've now been issued. And I won't go into them in detail, but in essence, what they're really concerned with is that when you're negotiating this kind of agreement, it's all about the mutual interests of the parties, the recognition of the long-term character of the contract, recognizing the fact that there will be pressures on it from changing circumstances. And it seems to me that these may give us the foundation for the kinds of principles we might refer a panel to if we do indeed grant them the ability to adapt the contract. So I think I should probably stop speaking there. And I'm very much looking forward to the discussion in due course. But I know Eddie is going to have a few things to say about these ideas. Eddie, over to you.
Again, thank you, John, and thank you, Samir, Anita, and everyone for joining us. Again, exciting discussion here. I think once you begin to contextualize these issues, you cannot help but begin to examine, the two key players here. On one hand, we're looking at a multinational company, very powerful, well diversified, with a lot of resources. But on the other hand, particularly at the time some of these negotiations or contracts were made, we're looking at countries that were under significant pressure for economic reasons, energy security, and yet still had a number of attachments to the resources. So they don't want to let go in a sense, but they're trying to see how best they can maximize economic recovery of these resources. And so, I've come across a number of papers that have, in so many ways and in different contexts kicked against the PSAs specifically and the stabilization clauses, to be more precise. But if we take a few steps back to understand the background for which all of this is happening, we're beginning to see that it is on the basis of an existential fragile state theory principle, which essentially means that we have a multinational negotiating with a country that is existentially fragile, in the sense that there is a lack of capacity, there is weak governance institutions and structures, and there are a number of issues that would impact the negotiations of the contract, and in which case we have seen some of these freezing clauses. That then begins to put the host country in a state where it is most times dormant rather than active in the course of the negotiations. And that is one of the issues I try to emphasize in my conversations, that how can host communities or host governments move away from that dormant factor and become more active? And in as much as you want companies and multinationals to play fair, they are there for a reason. And if you look at it, even if you take it a few steps further, you begin to realize that there are even historical context behind some of these issues. Otherwise, why would a host government give a multinational a license to exploit oil, not in a specific region, but in the entire country till they are satisfied? So if you look at these contexts, you begin to see why they would be signing some of these freezing clauses that today seems unusual. Unfortunately, these contracts are, as John has pointed out, 10, 20, 30, 40 years. And so we are beginning to realize what happened. How did these things happen? How did we sign these contracts? That then leads you to that understanding that if we do not develop the required capacity and the required governance structures, the required level of transparency on both parties, then we will continue to see engagements and clauses that are, in a few years' time, when we can really view these contracts and there's no more confidentiality, we will be amazed and deeply concerned. The question doesn't stop there. It begins to relate to, even as the world begins to transition away from fossil fuels, to other issues in the course of the energy transition discussions, and more specifically to the role of critical minerals. So as we begin to transition, and we're in a stage where most of these critical minerals are required for building of solar panels, batteries, wind turbines, and all of these things, we're beginning to see developing countries in the global south signing the same sort of agreements with really frightening clauses with host governments from, with multinationals from a number of different countries. I'm mindful of, calling out names here, but you begin to see some of these contracts that are really, really concerning. It means that nothing has been learned from the existential fragility of the states, hovering around a number of these indicators and contexts, even moving forward to the issue, to energy transition conversations. What that tells me is, in another 20, 30 years, when we begin to re-examine some of these contracts that have been signed in relation to critical minerals and energy transition, then a lot of disputes might equally occur. And that brings to the conversation to some of the issues that John had highlighted in form of the guiding principles. And although the objective is to ensure durable extractive contracts and a balance of legitimate interest between host governments, there are factors and indicators that are required to put host governments in a position where they can equally negotiate and achieve the overall objective for which they are set out, which is ensure that they maximize economic recovery, ensure that they are able to achieve the energy security in the midst of these resources, and ensure that they are able to navigate or mitigate the resource curse, as we have seen in a number of regions. So I don't think, even with the research that we've done and the paper that John has produced, the conversation ends here. It is increasingly complex, and in the wake of the energy transition, there are increasingly more troubling revelations that we are beginning to see. Now, the big question is, what would be done, what would be required, and how will host governments reposition themselves? How would African governments reposition themselves in order to avoid these sort of things? I was about 2-3 years ago, I was at a mining conference, Africa and Arab Mining Conference, and I listened to the presentations from the ministers of energies for some of these African countries, and I realized that unfortunately they didn't have as much data as the multinationals who were coming to sign the contracts. And you could see these tensions of the political economy of speed playing out, in the sense that there is this enthusiasm to maximize the resources, sometimes at the expense of really looking deep into the contracts that they're signing. And so it's almost like they're cap in hand with people that are more sophisticated, have more resources, human and capital resources, and in some sense, taking advantage of some of these host governments. And we will continue to see these issues if these things are not addressed. Again, we can continue to engage, we can continue to examine these issues. I'm happy to join John in answering a number of your questions, but the reality is this is not the end of the story. Thank you.
Okay, thank you, Professor Patterson and Dr. Now, we've only got the one question so far, but I've got a few questions that I can ask. And again, please, if you've got any questions, please ask. And I think I'm able to actually allow you to speak if you want to speak. But I suppose the first question, only question from Sabina Malik. She says, is it possible to get a draft copy of one of these contracts for learning purposes, or maybe some extracts that you can provide?
Absolutely. Yeah. So what I could do, Samir, is I could share the paper with you, and also provide an example contract, or also point you to where you can access these contracts, freely available on the internet. Over the years, it's an interesting point actually that for many years these contracts were really confidential. They were kept under lock and key, and that of course also contributed to problems, because there was no transparency, there was no sort of independent oversight of what had been agreed, and that always struck people like us as kind of odd, because yes, of course there can be an argument in terms of commercial confidentiality, but in essence, in many of these countries, what we're talking about are the most important fiscal arrangements, by orders of magnitude, and yet these were essentially secret. Now, as time has gone on, with things like the Extractive Industry Transparency Initiative, those sorts of things, more and more countries, as a matter of course, are making their contracts public, both as model contracts in advance, so people are aware of the basis upon which the details are being negotiated, and also actually the finally negotiated contract as well. So there are examples out there, and equally what has happened is that more and more have come into the public domain, even if in principle they remain secret, because people who have access to them in the country sometimes think, well, it's not really conscionable that we keep these things secret. So there are sources out there where these contracts are gathered. I'll send the details to Samir of where you can access them.
Okay, thank you. So I suppose I've got a few questions, and I hope that other people will ask questions. So slightly, well, not adversarial, but freedom to contract. If an oil developer has, used hard bargaining tactics to get a contract in their favour, what's wrong with that? They're all adults, aren't they?
Yeah, so that's a really good point. And I'm thinking about the best way to answer this. I think there's a lot to be said for recognizing that this is a matter of freedom of contract, and it is absolutely fine if you're simply good at the job, then that's great. What I would say though is that often it's not actually in the best interest of the company to drive the hardest bargain. Okay, so again, I'm not sure who's on the call, and I know it's being recorded, so I'll speak in kind of hypothetical terms, but this is based on real life. So I can think of one example where, again, it was a PSA, and the company had managed to essentially drive a really hard bargain. And in essence, that happened because the country concerned simply did not have experience, expertise to know what was happening. And what essentially happened was that whereas this is a risk contract, and as a consequence, that means that the risk should be borne by the contractor, they had managed to offload some of that to the state. Now, what happened then was that, one day the state woke up and realized, hang on a minute, we've been taken for a ride. And the state in that case was big enough to not to go to the company and say, we want to renegotiate, but just to make life really difficult for the contractor. Because they felt that they'd been done over, which they had, and they thought, okay, to complete that game, we will now make your life very difficult. So that's one example. And the other one, of course, is the social license to operate. If it becomes clear as the years go by that you have essentially taken the government for a ride, you have done something that is, out of all normal parameters for the division of value, at a certain point, that can cause political ructions to the point where it actually becomes impossible for you to operate because you are, politically a pariah almost. I can think of one contract at the moment, which I will be astonished. I will be astonished if in the next few years there is not political trouble over that contract, because it is shocking in terms of the division of value. No one operating in the industry would have looked at that and thought, well, that's a good deal for the state. They would have looked at it and said, for heaven's sake, don't sign that. Instead of which they've gone ahead and done it. And once everyone kind of realizes what's gone on, the oil companies concerned will feel the heat, because it wasn't fair. It's not a fair deal. They do not need. There are no circumstances in which they would have needed that amount of return to justify the risk they've taken. It's pure gouging. Now, again, it's business, but it's a very particular kind of business, and it's not two commercial actors. It's the state's natural resources, and usually, you will look at the constitution of the state, and you will see that the state holds those resources in trust for the people. And if the people come to the conclusion, you know what, this hasn't done well, yes, they can blame the government for signing a bad deal. They can certainly blame the companies for taking advantage. So I've got sympathy for it's business. Do the best deal you can. But I think everyone needs to be aware sometimes the deal could end up being too good, and that will come back to bite everybody.
Sorry.
Okay, no, I was just going to add that again, just following on from John's point. I mean, the oil and gas industry is a really, really tricky and sensitive environment to work in, and in a number of ways, we have seen example where, as John mentioned, host communities have revolted against multinational companies, and in a ways that they've not been able to extract oil from that region in the way that they had anticipated. A clear example is the Ogoni crisis back in the Niger Delta region, where since 1995, a multinational company has not been allowed to step within that region. And that's not the government doing it. That is a host community. So you cannot really hold the government, because their hands are equally as tied. And of course, there are more extreme circumstances where some governments, depending on the regime in power, would just maybe nationalize or just tell people to get off. Of course, there are consequences to that. But again, like John mentioned, it's better to be transparent, and especially when there are concerns around transparency, because we do understand that there are circumstances where some multinationals would hold back information, would be less transparent, would try to play smart and all of that, and in those cases, it does backfire.
I suppose one question for you, Doctor. You mentioned that other extractive industries are following the same pattern as tying up full contracts. Why do you think the governments haven't learned lessons from the oil and gas experience?
Sorry, take that again.
From my understanding, you've said that other extractive industries, they're sort of signing similar unfair agreements, if that's right. Why do you think they haven't learned the lessons?
I mean that's a fantastic question. You know, again, it boils down to the pressures. All right. So once you have existentially fragile states, the priorities are quite different. You know, the priorities are maybe get what you can now, and you know, there's some expectation that they would build capacity over time, and it's kind of led us to some of the questions where we ask, you know, sometimes, do you want to hold back you know, recovering or maximizing these resources until you've built capacity, or can you do both at the same time? So in some cases, there's a good intention to say we cannot sit back and sit on these resources and do nothing while we try to build capacity. And so let's just get what we can and build capacity over time. But because we're dealing with an already existentially fragile state, if there isn't a very clear long-term strategic vision, then in some cases, governments change hands, the other guy comes again, all right, wants to do the same thing. And over a period of time, 10, 40, 50 years, they are still where they are. A country like Ghana, for example, I remember when they started, you know, over 10 years ago, trying to develop their oil resources and all of that. The big question was, we will do everything we can so that we're not like Nigeria. Well, 10 years after, Ghana is asking the same question. What, you know, what have we gotten wrong? And that's just next door. You have a case study next door where you can learn all the lessons and avoid repeating the same mistakes. But yes, they still do the same thing. But it's this idea of the political economy of speed, which is we want to maximize. And there isn't much attention paid to diversifying the economy. And that's kind of the arguments we now have in the cause of energy transition, that you cannot claim to have had oil for 50, 70 years, and you're still holding on because you think, you know, that's going to be, you know, your secret sauce. That's going to be your gateway. Unfortunately, you haven't done it for 70 years. What makes you think you're going to do it for the next 30? And if you don't diversify your energy system, then you're going to run into more problems. So the question of energy transition, as much as climate change is important, is equally an economic, you know, discussion rather than just an environmental.
Okay. I think one question for me, and again, I'm asking the audience if they've got any questions, please don't be shy. Either type them or raise your hand and you can answer them directly. But with the development of growth of countries like China, India, Korea, you know, that they're starting to tell like multinational or development countries. Do you think that's actually a good sign for Africa, that there's more competition to get their resources, therefore they're in better position to negotiate, rather than just relying on the sort of traditional UK, US, Western Europe or majors?
Eddie, can I just say a few words first, because I know you're going to have a lot to say about this one. I think we're in a really interesting position. I'm using interesting in an interesting way there. Things were already complicated before, you know, what we're dealing with at the moment in the context of the invasion of Ukraine. Because the thing that we haven't really spoken about in all of this is the fact that these kind of contracts operate in the context, in a geopolitical context as well. You know, I mentioned briefly that we're dealing with resources which are economically and politically important. That doesn't matter if it's oil and gas or if it's critical minerals for the energy transition. You know, these are geopolitically incredibly significant. And then the issue is, what other factors are in the equation when, for example, not only are we dealing with individual production sharing agreements, but we might also be dealing with bilateral investment treaties or even multilateral investment treaties. And of course, what we then find is that in some cases, countries are willing to provide support, but there are conditions. And the conditions are usually around things like improvements in governance and transparency and things like that. And there are other countries who will say, I'll come and do a deal with you, no strings attached. And you know exactly who we're talking about in each case. You know, there are countries who are not going to ask any difficult questions, who are not going to put any conditions on the deal, but you know, is that really helping? So in actual fact, you know, if we look at the picture at the moment, which has become immeasurably more complicated in the last few months, I mean, really to an extent that is quite terrifying. We're looking at a transition which needs to happen, you know, incredibly quickly. And it is, you know, without any exaggeration, the most complex and demanding problem we've ever faced. And it is the kind of problem that will only ever be fixed if we can do it in a coordinated and cooperative way. And we're then trying to do it in a context where there is now less coordination and less cooperation than there was even last year. And last year was worse than the year before, and that year was worse than the year before that. We're going backwards in terms of the kind of coordination and cooperation that we actually need. Now, put all that together, and one could become pessimistic, okay? But I think what it does reveal is the extent to which we can't really kind of glory on in this kind of way going forward. We're going to have to, you know, take some steps. My sense is, unfortunately, that it will take something really, really serious to finally get us to focus our minds. But by that time, it could well be too late. The risk of becoming more negative, I'm going to hand over to Eddie and hopefully be more optimistic than me, Eddie.
Well, I hope I don't disappoint. Because you see what we're dealing with here is, again, countries in the global north back to this dormant and active concept. There's need to step away from that and become more proactive, and that would require, in some cases, less reliance in external forces in other jurisdictions to solve our problems for us. Take a country like Nigeria, that would be the third largest country in the world by 2050, and yet a significant amount of citizens do not have access to energy, let alone clean energy. I mean, you know, you're the same thing if you look at the African continent. We have almost 60% of that continent not having access to energy, let alone clean. So you then begin to see that the conversation is no longer about the luxury of an energy transition, but to begin to redesign an approach that is more organic, what is more homegrown, and in a way, something I refer to as the energy revolution, which means looking more inward and identifying what have we got and how can we use that to solve our problem. It's kind of what we talk about between the Norwegian model and the Norwegian method. It's beginning to re-examine all those issues and look inward, but that would require a lot of, you know, plugging of the waste. You need to cut off all the waste that is going on, because I see when people make the argument that, you know, we cannot transition because we don't have the money. But we are seeing countries spend trillions or billions of dollars in subsidies for fossil fuels. And it doesn't make sense. You know, you cannot sustain that argument. And so if you don't have, again, moving away from transition to an energy revolution, because of what you have is a crisis. And when you have a crisis, it's no longer business as usual. We saw what happened with COVID. It was no longer business as usual. Everyone stopped. We basically stopped, you know, and we're stuck indoors. And so with the kind of crisis we're having in terms of energy poverty and energy crisis, we need a revolution, an energy revolution to resolve that. And that wouldn't come from, you know, the reliance on the UK or the US and China, because all they are doing is looking after their own interests. And once the interests are no longer aligned, then they're done. We saw US at a point was one of the largest importers of oil from Nigeria. Today, it's a completely different story. So we're seeing the geopolitics of it evolving. And if we do not strategize to avoid, you know, for the crisis, then we're going to run into troubles. And that leads us to a conversation where we're looking at an energy revolution in consumption. So how we're using the resources, an energy revolution in deploying the technology. All right. China started with nothing. Today, they are 80% of the offshore wind energy production and manufacturing market. How did that happen? So I think it's more complex, again, as John points out, but we need, you know, a more strategic and homegrown organic approach to solving some of these tensions.
Samir, can I just sort of complete that? Because, you know, I'm mindful that it's very easy in this discussion for us to kind of drift away from the issue of dispute prevention and resolution. But of course, the interventions that we've both just made, I think, also give us an indication of the pressure that is going to be on a lot of contracts in the years ahead. So for sure, if we look at the ones we were focused on to begin with, the oil and gas production sharing agreements, Eddie already mentioned, that some of these issues will get more intense. So think in terms of, for example, internationally agreed targets, reducing our reliance on fossil fuels. Some of these contracts were written and negotiated on the assumption that they would go on for a long time. What if we end up in a situation where certain countries are decide themselves to reduce production or cease production early? What if we end up making that decision on the basis of methane emissions or other environmental damage? We can already stack up countries on the basis of which is the best oil to produce because it's low methane, etc., which is the worst. So what about agreements in those countries? What if they end early? What sort of balancing or compensation could be envisaged for oil companies? Are they going to get anything, or are we simply going to say to them, sorry guys, live with it? But these are the kind of big questions that are going to come. And then of course, we look at these broader geopolitical issues as well, and already, and it's possible that people on this call are already dealing with this. As we deal with contracts, whether they could be supply, transportation, sales contracts that are affected by sanctions regimes, embargoes, you name it. We're entering a period, where we might even see really unprecedented pressure on existing long-term contracts, and the kind of issues that we've talked about today, very much in the context of one kind of contract, could actually ramify across, the whole energy value chain, whether we're talking about hydrocarbons or other sources as well. It's really an intriguing but quite challenging set of problems.
I've got plenty more questions, but I think I'll spare everybody else from listening to them. I just want to give one final chance. Anybody would wish to raise a question before I just sum up? Raise your hand if it's going to take a few minutes to ask it. Please do. See, there's no. Okay, I think everyone's probably too amazed with your both of your talks actually. So, can I say, on behalf of the West Midlands branch, thank you, Professor Patterson and Dr. Buffer, and also our committee member Anita, who helped to actually start this whole idea of this webinar. So, as mentioned before at the start, the West Midlands branch does do events on all topics of alternative dispute resolution, and we're always welcome to hear any suggestions from the globe actually in our next event. Our actual next event should be on blockchain and smart contracts, which should be a hybrid event, so taking place in the University of Birmingham University and online. It would be advertised on the CIArb website. I'll just say thanks again to Professor Patterson and Dr. Wiffer. I think it's a very interesting talk, and wish you best in your research, and hope to see some nice papers.
Yes. Thank you very much.
A pleasure, absolutely. So as I said before, I'll share the paper with you and the link to contracts. And equally, if anyone in the audience has questions that they think of after, easy to find our email addresses online at the university at the Centre for Energy Law. Just drop us a line and we'll be happy to help if we can, for sure.
Okay, sorry, I think we've got one question. Sorry. Yep. Yeah, so I think a question from could you receive John's paper and some precedents? So if you send that through to me, John, I'll forward it on.
No problem. I'll certainly do that. Yeah, and as I say, if any questions occur after, just feel free to drop us a line. We'll be happy to help. Okay.
All right. Thank you all again.
Well, thank you very much.
Thanks very much indeed. Have a good evening, everyone.
Thank you.
Bye.
Bye-bye.
Bye.